you.
And then item 8 is Brian.
Yeah. This is memorandum 2022-40. It's a couple of minor estate planning items. These are both spin-offs from the work we did on revocable transfer on death deeds. And we're just making a little more progress on the development of these two ideas. Not as much progress as I'd hoped, because when I was preparing yesterday, I realized that I had overlooked something fairly important about the first one. So it's not quite in the posture that I thought it was. But let me just get into the substance. The first of these issues has to do with what's called ademption by extinction, which is when you create an estate planning instrument that makes a specific gift. So it names a particular asset, my car, and it makes a gift of that asset to a beneficiary on your death. What happens if you no longer own the car or fully own the car when you die? And the general answer is what's called ademption by extinction, which is the gift is revoked. The policy is that getting rid of the asset before your death is either tantamount to a revocation of the gift, or it is evidence of your intention to revoke. But either way, the general rule is if you don't have it when you die, then the gift fails. There is a provision in the probate code 21134 that creates an exemption to that general ademption rule, which is if the asset was lost while you lacked decision-making capacity and were under the protection of a conservator, guardian, or attorney in fact, and they're the ones who are responsible for selling the asset, or it was their watch when it was otherwise lost, destroyed, encumbered, then there is not the same policy presumption that you intended to revoke that gift. It was not you doing it. You lacked the capacity to do it or to understand it, perhaps. And it's the person protecting you who did it on your behalf. And so in that situation, the statute provides a substitute pecuniary gift. You can't get the asset, the specific gift, because it's gone, but the law provides that you will get an equivalent amount of money. This was drawn to our attention by the Executive Committee of the Trust and Estate Section of California Lawyers Association, TexCom, to their friends, and John Anderson, our current liaison from TexCom, is present. Thank you, John. They brought it to our attention. They said, how does this work when you got a revocable transfer on death deed? And one of the issues was, is it sufficiently clear that a revocable transfer on death deed makes a specific gift, thereby triggering this code section? And we said yes. We concluded yes. And I think we maybe added some language to emphasize that. But the more troubling question was, if you've got an instrument that only affects a single asset, like a revocable transfer on death deed, it's just a piece of real property, and that property's gone when you die, and so your beneficiary is entitled to a substitute pecuniary gift, where does that money come from? It's not clear in the statute. The answer is not clear. And it's not just revocable transfer on death deeds that it's not clear. It's not clear for anything. So if you had a transfer on death registration of your very expensive mobile home, and then you sold it before your conservator sold it before your death, where does that money come from? The statute doesn't tell us. So it's not a problem created by the RTOD deed. And so we decided to take a look at it and see if we could come up with some clarification. And where I started in my thinking about it was that really it ought to come out of the person's general estate. And I'm using a non-term of art there intentionally loosely. but it should come out of their general estate. So they sell the RV or the house or whatever, that money's going to go somewhere and it's going to fall into their estate. And so if you're going to make an equivalent gift to effectuate the decedent's intentions, it should come out of the general estate to restore the intended status quo and to avoid a windfall to the other people who would otherwise receive that money if it fell into their portion of the estate. And so as a starting point in the memo, I suggest that it ought to be that it comes out of the general probate estate or the trust estate, because those are the instruments that can govern multiple assets and that can be set up to act as a residue collector, right? If you have money or if you have property that's not governed by any instrument specifically, it's going to fall into the residue of the probate estate, or if the trust is set up with the right terms, it could fall into the trust estate. So I thought, okay, well, the proceeds from the sale of this property is going to fall into the probate estate or the trust estate, then the gift ought to come out of the same pot. And then I went on to elaborate with some more details about, well, if that's the case, there ought to be a rule that the probate estate is exhausted before the trust estate, because that's general policy in existing probate law in California. The probate estate is liable for the debts of the decedent before the trust estate is liable. And then I also suggested that because this section 21134 says that the substitute gift is a general gift, that we should not disturb that very careful distinction that's drawn in the statute, because general gifts are consumed to pay off debts before specific gifts, and general gifts to non-relatives are consumed before general gifts to relatives. We ought to keep all of that carefully thought out, longstanding policy about the order of abatement in place. And so I wound up with this draft that proposed that we say that it should come out of the probate estate if the probate estate is sufficient, as if it were a general gift. And if the probate estate is not sufficient, then out of the trust estate as if it was a general gift. And I thought, okay, that seems correct. That seems like that's how it probably does work and how it probably should work. But yesterday when I was preparing for this meeting and I was going over that material again, I realized something that hadn't occurred to me before, which is I had sort of been assuming that the proceeds of sale of the asset that was disposed of by the conservator or whoever would just fall into the general estate, right? You'd get a check for the RV that you sold, you'd deposit it in your bank account. And that's when a little light went off in my head and I realized, oh, wait a minute. There are bank accounts that are non-probate transfers. You can have pay on death bank accounts. And so if the proceeds of the sale of this extinct asset went into a bank account that is structured to operate as a non-probate transfer on death, then you're creating a windfall for the beneficiary who's supposed to get the money in that account. And so taking it out of the general probate estate is not the right result, because that shorts the probate estate to the benefit of whoever was designated as the POD beneficiary. Does that make sense? Okay. So I realized that I have to come at this again. I don't think this item is ready for decision today. And unless somebody sees it differently, Commissioner or Mr. Anderson has a different light to shed on it, what I would do is bring it back at the next meeting with a different version of the proposal that would include a prong that says, if the proceeds of the, I'm going to say sale for simplicity's sake, although it's not just sale. If the proceeds of the sale are deposited into, and this still makes me nervous, but deposited into a pay on death account, that the pecuniary gift shall be drawn from that account. The problem that still makes me worry, and that I'm not sure how I'm going to grapple with, is that, you know, those accounts are liquid. The person whose account it is can use the funds in there during life. And so, you know, there's no, if the money's deposited into the account and then withdrawn to pay for an assisted living facility, it's not in that account anymore. And so to stick the POD beneficiary of that account with that liability, that might not be the right result. And that makes me think the only answer is like some complicated tracing scheme. And now I'm thinking, what am I doing? Is this enough of a problem in practice to justify creating this really complicated structure to deal with this? So I don't even know at the next meeting whether I might come back with a suggestion that we just walk away from this as, you know, more of a solution than the trouble justifies.
Mm.
One of the things you hate to hear when you're in a legislative policy committee is somebody say, is this a solution in search of a problem? You know, you're in trouble if a member of the committee says that, but that's kind of what's rattling around in my head about this, is whether maybe we leave well enough alone and if it's not actually causing problems in practice. So I think I'm happy to hear from any commissioner, but I'd also like to hear from John if he has a different reaction to what I've just said.
So I have a quick question. I know nothing about this area of law. It's not school finance, so it's not my stuff. I mean, in your example of the person who has legal authority over the person's assets, I mean, suppose they didn't sell it, they just like gave it to the son or something. There's no sale proceeds to go in any kind of account. Well,
I think you'd
what
still,
happens to that?
I'm not sure that you could do that in reality. I think if you were going to make a gift of assets, you'd have to get court approval. And if there was already another instrument to dispose of the asset to another person, I think the court would be skeptical of a conservator, that action is in the best interest of the conservatee. The other kinds of examples that we have, though, are things like it burns down. It's stolen. It is, you encumber it. So you take money, you take equity out of it. There are a lot of different ways in which the value of it can be diminished. But the policy of the state of California is that doesn't mean that the transferor intended to revoke the gift. So we're gonna make the substitute pecuniary gift, even if the money's gone. You know, and then let the regular rules about how to apportion gifts if the assets are insufficient control. But we're not going to just say that the fact that the conservator found it necessary to liquidate this asset means that the transferor meant to revoke the gift.
Okay, thank you.
Can we hear from John Anderson?
Mr. Anderson?
Yes, good morning, commissioners. Can you hear me?
Yes.
All right. My TexCom colleague, Ryan Zapanik, may be on the call as well. So if he is, I would invite him to chime in with his thoughts. Let me first say that, unfortunately, this memorandum didn't come to our attention until earlier in the week. So I have not had a chance to present it to the full committee to get feedback from TexCom as a whole. So I'm basically here to provide my thoughts as a state planning practitioner who deals with these things in real life. And then, you know, we can, if the committee decides to go forward with this, we can of course then bring it back to TexCom for more consideration. So with that introduction, I would say that where I am at on this issue is exactly where Brian is at on this issue, the way he described it. I ran through numerous thought experiments in my head on how this could potentially work in different scenarios. And I always, in many cases, came up with situations where it did, no particular option really made sense. So I think that this is trying to draft a solution for this problem would be, it seems to be quite complicated, and would not necessarily always get the answer right. I would also say that in my experience, this has not to date been a problem. I realize that we're the one who kind of raised this issue in connection with the RTODD statute, but I have not personally seen this arise as an issue, nor have I read in, the estate planning treatises and the estate planning literature of this being a problem that practitioners are confronting. So those are my, that's my input on the issue, and I would let let Brian and the commission decide on whether it makes sense to proceed.
John, is this the kind of thing where in reality, the personal representative would just ask the judge for guidance? I mean, if it was unclear how it was supposed to work, they knew they had to make this gift, but they didn't know where it came from, could they ask for instructions of some kind?
They potentially could, but I mean, it isn't. I mean, I think there's a couple of issues going on here. First of all, I know that, I'm thinking specifically of revocable transfer on death deeds. I know the staff has concluded that that is equivalent to a specific gift under a will, but the statute doesn't say that, and there's no case authority for that position. So I'm not sure. First of all, there's that threshold question whether this would apply in the first place. The statute works pretty well when you have a specific gift under a will and you have an estate, and that's where that's where the situation typically arise. I would think that if the case comes up with a revocable transfer on death deed or some other type of standalone estate planning instrument, then I think there will probably be a lawsuit on the issue, and some of these things will have to be will be determined in litigation.
Do you know how it works with trusts?
With trusts, the advantage, in a simple situation, let's say the decedent had one trust that was sort of their catch-all estate planning instrument, then it would work basically equivalent to a will with an estate, because you would have a trust fund with presumably other assets that would be available to fund the pecuniary gift. In addition, in the case of a trust, if you had an asset that was in trust, there was a specific gift in a trust, and that asset was sold, the proceeds would wind up back in that trust. So they would, that money would be, at least whatever's left of that money when the decedent died would be there to fund the substitute pecuniary gift as well.
Yeah. Yeah, and it all makes sense. So I guess the one possibility would be to just table this and not do further work on it. I mean, if I were to do further work on it, I would try to bring back something along the lines of what I suggested, which is, a more nuanced approach that recognizes that the funds might be deposited into a transfer on death bank account, but then I really don't know what to do about the issue about tracing, and it's, I guess I'm kind of down on it.
Any other thoughts from commissioners? Let it go. I mean, to quote Princess Elsa or whatever.
I move we let it go.
This is second on that.
Is there a second?
I see nodding heads.
Sure.
Yeah,
Yeah,
okay.
it's been seconded.
All right, I'm gonna go ahead and call the roll.
Okay.
Carrillo,
Aye.
Cubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Okay, thank you very much. At least we didn't go all the way to a tentative recommendation before we found out that these problems were under the hood. So the second item, I'm also feeling a little skeptical about, sorry. It is another spinoff from RTOD deeds. There was especially when we were looking at stock cooperatives in particular, because stock cooperatives are an unusual species of real property development, because what the individual owners of units in a stock cooperative own is a share of stock. They don't own titles of real property directly. And so all of their rights, all of their use rights and restrictions on their rights are expressed in governing documents. They're not in a deed. They're going to be in perhaps the bylaws of the corporation that owns the property. They might be in rules adopted by the board. They might be in contracts. A lot of times I understand that people who buy stock co-ops acquire what they call a proprietary lease or a use agreement. And so the terms of what they own are determined by these off-record restrictions on use, grants of use rights and restrictions on those use rights. And so it was particularly important in the context of stock co-ops that we think hard and get right the issue of what effect use of a revocable transfer on death deed to transfer an interest in a stock cooperative might have on the enforceability of these off-record rights and limitations. And we spent time on that. I think we got it right. But we concluded that, maybe it might be helpful to address the same issue globally, so that it's clear no matter what kind of estate planning instrument you use to transfer real property on death, it does not defeat use restrictions on the property. You take title subject to those restrictions. So if an elderly relative leaves me her condo in an age-limited senior community, I acquire title to that condo, but it's still age-limited. I can sell it, I can rent it, but I can't live there. Actually, now probably I could. Take that back. So we thought about addressing that as some sort of global general rule. And when I tried to put the global general rule into language, it made me uneasy. And in fact, in the memo, I asked for input on whether there were problems with the wording. And see if I can find it.
And then we'll move on to.
I don't know who that was. We're having some odd auditory stuff. So I suggested adding a general provision in the rules, in the part of the probate code that includes general rules of construction for all instruments. Just saying something like an enforceable restriction on the use of property does not affect the transfer of title to that property. And we said something similar about the transfer on death deed, but it was in a context in which I think it made more sense. It was more enlightened by its surroundings. And I just still feel this uneasiness that such broad language standing by itself in a set of rules of construction might lead to misunderstanding or have some unintended consequence. I don't see one yet. But I guess I'm feeling like it might be prudent to just back off this one too. This came to us sort of as that might be nice to do too, to provide some clarifying guidance. But that concept of providing clarification isn't a real strong need. It's not like something is broken and we have evidence of a problem. And so I think maybe I should have a little hubris and back away from this one as well.
Okay. Any comments, questions by commissioners?
I move we let this one go too.
Okay, is there a second? I'll second. Yeah, Kara second. Okay.
Carrillo,
Aye.
Cubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Okay,
Okay.
that's that memo. And so the only thing left, I think, is the trial court restructuring stuff. We skipped.
Exactly. Yep.
Okay, so trial court restructuring, some of you remember this from back in the day. Some of you learned about it from Barbara in the last year or two. This is a decades-long project that the commission has had to conform statutory law to some significant restructuring of trial courts in California. It started with what we call trial court unification, which was effectively the elimination of the municipal and justice courts in California, so that in each county now there's only one level of trial court, which is the Superior Court. And then it was followed by some big changes that moved the financial and administrative and operational responsibility for courts from the counties to the state. And there were a lot of statutes that were drafted under the old systems that needed to be tweaked to reflect the new systems. And we have done the lion's share of that work. I think we're probably over 90% done. But what we're left with is the hard nuts, the issues that just weren't ready for, that weren't ripe for reform yet because of facts on the ground, or that we're seeing diminishing returns. They're increasingly difficult to track down and solve for increasingly smaller benefit. And so a lot of this stuff just gets repeatedly postponed because we have other higher priority projects that come our way. So the work is out there to be done, and Barbara did more of it in the last couple of years. And this memo provides updates on a couple of pieces that she broached earlier that I thought, well, maybe I can keep the ball rolling and make some progress on these. The first one of them, no, I couldn't make progress. It was the one about the Lassen County Courthouse Construction Fund. And the commission had originally concluded that that fund was no longer needed. And so the statute that governed it could be repealed as obsolete. And we put that in a tentative recommendation. And we got feedback from County Counsel's office in Lassen and from the Judicial Council. And they said, no, actually that fund still exists. It still has money in it. And the courts and Lassen are in talks to figure out what to do about it. And one of the reasons why I wanted to revisit this now is because the attorney for Judicial Council who helped us with that, Charles Martel, was a long time, very helpful aid to the commission in understanding a lot of this stuff. He just retired. So I wanted to get in before his retirement date and ask him if there was any new information. There's no new information. The talks are ongoing. But at least I rattled their cage, and he said he would nudge the people involved and remind them that we're waiting for a resolution, but there is not yet resolution. So that's information only. The second topic has to do with a penal code provision. Penal Code section 1463.5. And this section is in the deepest depths of the complexity of trial court restructuring because it relates to the allocation of fee and fine revenue collected by the courts, which is extremely complicated and extremely important and sensitive. But we had noticed this one section, PC 1463.5, that talked about how courts, trial courts, are to calculate the amounts that they distribute. It gets distributed out in a very complicated manner, but how do they calculate the distributions for this revenue that they then have to send along to other entities? And this section says that courts can use probability sampling to figure out their distributions. And I couldn't find any guidance on exactly what that meant, but my assumption is that it means you don't have to do a comprehensive accounting of every transaction. You can do sampling of transactions in order to get a reliable rubric about like what percentages of the total revenue you're receiving goes in this pot, etc. And you can base it on statistics rather than comprehensive actual accounting. In this section, one of the reasons it caught our attention is because it says that the method is to be devised by the county auditor, which looks like it might be an obsolete vestige of the former system, and that it has to be approved by the county board of supervisors in a majority of the cities, which also looks obsolete. And it concludes by saying that there will be a biennial audit of the distribution, assessing the probability sampling method conducted pursuant to Government Code 71383. And we knew from some other work that we had been doing in the vicinity of that section had been repealed. So we've got this requirement that an audit be conducted pursuant to a section that doesn't exist anymore. And we had to figure out, well, what are we going to do about that? How should that be fixed? The historical form of that section, I just realized I skipped over a memo, so I'm doing the memos in reverse order, sorry. The historical form of 71383 is that it required the state controller to do a biennial audit of trial court distributions. And when I looked at the article that 71383 would have been located in if it had not been repealed, the very first section of it, 71380, says that the controller, amongst other things, shall do a biennial audit of trial courts' revenue distribution. And so I thought, well, maybe this is the successor to the repealed provision. It's not actually, it's more complicated than that historically, but I thought maybe it'd be an adequate replacement to refer to this 71380 rather than 71383. So I found the people in the controller's office who are responsible for these trial court revenue distribution guidelines and audits. And I asked staff there, is this section still used? Do they still do probability sampling? And if so, is the audit that's conducted the 71380 audit? And the answer I got back from them after they sort of knocked it around internally was, that's probably obsolete. We don't think any court is doing probability sampling anymore. They suggested people at the Judicial Council that I could talk to who were the experts there in trial court revenue distribution. And their response was similar. They said, I don't think that any trial court is using that section anymore. And as I say in the memo, they hedged what they said. They both qualified it. And also, this is informal staff level response. It's not considered position of counsel or of the bodies that they represent. So we have unofficial input that was a little hesitant. And I think that hesitancy makes sense because if this stopped a decade ago, why would anybody there know anything about it? And how can you be sure what the 58 state counties are doing? Except that they did say that they thought it had been replaced with a case management system that did actual accounting and calculations. So it seems likely to me that that section is wholly obsolete. And that I have the best information I can get without sort of escalating and trying to get the people, the superiors and the entities to focus on it and confirm that information. And so my suggestion was maybe we put this into a tentative recommendation and make sure we do the usual distribution to the Judicial Council as an entity and to the county councils. And we'll send it to the State Controller's office. And maybe if they see it in that form, we'll get an official response, which will firm up our understanding, or maybe we'll get the same kind of response that, you know, we don't really know. And then we'd be in a position to know whether we want to take the leap and repeal this section. But I think it's ready for integration into a tentative recommendation and distribution for comment, and that would be my recommendation.
Okay, any comments or questions from commissioners?
Just
Yeah,
one quick question, Brian. Having worked on this project under 2 prior governors over the span of 20 years, how many more pieces of this are left? Or are these 2 shards the final 2?
They are not the final 2. One of the things that we had undertaken and then set aside, and so it's incomplete, was a fairly large labor-intensive process of searching the codes for code sections that refer in the same breath to counties or boards of supervisors and courts. And then examining those hits to see whether those sections contain any material that appears to be obsolete because they were drafted under the former system when counties were responsible for court administration and court funding and court personnel, right? We've done a lot of sweeps like that in the past that culled out obsolete material, but that was one that we didn't complete. And I actually started trying to revive it, and it was awful. I was finding provisions where I was thinking like, oh my, how am I going to figure out whether this is obsolete or not? An example is it says something about, you know, in a court where if court personnel have their salaries paid from county funds, X, right? And then there's a rule. And so I am going to have to, if we were to resolve whether that's obsolete or not, I'm going to have to go back into the law, but also the practice to figure out what does that mean. You know, it's clear there was this nice statute that handled a lot of the transitional issues on trial court funding responsibility. And it has a section that says these are court operations. And then there's another section that says the state shall pay for court operations. And one of the court operations is salaries. But I know from Barbara's recent work that's in some counties pay supplemental salaries to judges above what their state salary is. So, and that exists, and that's going to continue. And so that to me seems like a situation in which trial court personnel are being paid part of their salary from county funds. I also have seen provisions that talk about deposit of certain money, court money into county funds for some purpose relating to accounting or the triggering of consequences. And so it might be money that started with the court that's handed to the county in order for them to do something to it and then hand it back for its actual purpose. And I don't know if those kinds of pass-through things would trigger this section that's conditioned on salaries being paid by counties. And so I see that and I think, you know, that one section that would take me weeks
Mhm.
and I might never find the answer.
Well, and Brian, I guess I certainly support your current recommendation.
Okay.
I guess my question is, do you see a point at which we declare substantial victory and then move on? Or is this a perpetual process in your view?
I guess I'm not prepared to answer that today. I think that I would have to look harder at what's left on the plate to see whether there are portions that we could do fairly readily. I think I maybe jumped into the deep end. But I think that question is a good one that has occurred to me and might be worth asking in connection with new topics and priorities.
Right.
I think if we were to do it, it would have to probably have a statutory component to what our action, because right now we've got an outstanding statute in the government code that charges us with this work. And, you know, if we were to decide we've done as much as we can in a cost-effective way, I think we'd want to report that to the legislature and amend that section.
And that's where I'm heading. I know
Yeah.
this consumes an immense amount of time. And at some point, we hit the threshold of de minimis returns on an extraordinary continuing amount of time.
Yeah.
Okay.
Yeah, I agree. I mean, I'm sympathetic to the underlying notion of wanting to, you know, get rid of obsolete code sections. But, you know, if it takes a huge amount of work to figure out whether or not something's obsolete and it's not hurting anybody sitting there in the civil code or the whatever it is, government code or something, then, and it may not be worthwhile, you know, sort of spending that kind of time and effort.
Also, I hate to pass the buck, but some of this stuff, in order to find the answers, I have to grill counties and the
Mhm.
judicial council. And it feels a little out of kilter to have like a generalist who doesn't know this stuff, trying to track down the people who do know the stuff. So, you know, some of these problems, if they ever actually explode, the people who would know how to fix them is not us. It would be the courts. Yeah, I mean, certainly that's been in my mind, David. But I have to think more about it, and I think we have to have more of a discussion than just what we have here. I'd like to frame it with a memo and invite people who are stakeholders in these issues and have a better, more fuller discussion. But okay, so I think I heard a motion to hold this item, this penal code provision for inclusion in a tentative recommendation. And I can't remember if I called the roll,
Not yet.
so I will. Carrillo,
Aye.
Cubas,
Aye.
Ebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Hi.
Thank you. So I said I skipped a memo and I did. I skipped 2236. Sorry about that. This is a draft of a recommendation for approval. It is a narrow little technical piece of trial court unification, which is when we did trial court unification all those many years ago, what we were doing was conforming the statutes to a system that used to be bifurcated, that used to have muni courts and superior courts, and each of those courts had its own jurisdictional standards and its own procedures and its own appellate path. And when they consolidated the muni courts into the superior courts and eliminated them, those distinctions were preserved, but they were translated into a statutory classification system between what we called limited civil cases and unlimited civil cases. And so the limited civil cases are the cases that used to be muni court cases. And the unlimited civil cases are cases that used to be superior court cases. before unification. Okay. So we received input from a practitioner saying that there was this one issue that was generating confusion around the proper classification between limited and unlimited. And it was a civil proceeding to contest forfeiture of property, civil forfeiture of property in relation to drug crime. And it's definitely a civil proceeding. And when we looked at it, we concluded that it was definitely an unlimited civil case. Okay, because the way we were certain about that was that the statute that specified the jurisdiction for this case existed before trial court unification and said it was to be brought in the Superior Court. So everything that was to be brought in the Superior Court before unification is necessarily an unlimited civil case. That's almost definitional. So we're quite confident that we know what the right answer is. The issue, I think the reason people are confused about it is because one of the criteria used to differentiate a limited civil case from an unlimited civil case is the amount in controversy. How much money is at stake? And the amount in controversy limit, I believe, I don't know if it still is, but it was $25,000. So 25,000 and under, that's limited. Above, that's unlimited. Well, there's a $25,000 distinction in the civil forfeiture statutes too. If it's under $25,000 that was seized, then the state can proceed non-judicially. Okay, unless the person whose property was seized files a claim, in which case there has to be a hearing and it goes to court. If it's more than $25,000, then it cannot proceed non-judicially. It always has to have a hearing. So there is this overlap in the distinction between limited and unlimited, that $25,000, and between necessarily judicial and potentially non-judicial, which is 25,000. And so the person who wrote us said people are confused about that. They think if they go into court and it's under 25,000, that's a limited civil case, because that's the amount of controversy. And the statute simply says the action shall be brought in Superior Court, which doesn't tell you anything about whether it's a limited or civil case unless you also check to see whether it said that before unification. So the commission worked on it. We did a tentative recommendation, very straightforward, a couple of clarifying changes consistent with what I've explained. We sent it out with targeted distribution, and Barbara was always great about making sure that everybody who might be interested and have something to say has received a copy. And I listed the distribution in the memo for you. We also sent it under our normal mailing list, which includes a lot of people who are interested in these kinds of things. We got no comment back. In this context, because the change is entirely non-substantive, and I'm virtually certain that it's correct, I feel comfortable proceeding without any supporting comment, and then everybody just looked at it and shrugged, and they said, yeah, that's right. And they weren't interested enough to write us a letter saying that. So my recommendation will be that we make this a final recommendation.
Okay, thank you. Any question or comment from commissioners?
Unless there are any, I would move it to a final recommendation.
Is there a second?
Second.
Seconded by Jane. Is this, I don't know, the people who were still attendees, is this something, any of them?
It would have to be, two of those people are our staff.
Oh, yeah, okay.
I don't see any hands coming up.
Your hand coming up? Okay.
Nope. All right, I'm going to call the roll then on that motion. Carrillo,
Aye.
Cubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye. And that does it, right?
That's the meeting.
Okay. Are there any other questions, comments from commissioners before we adjourn? All right,
So we're going
Thank
to
you,
be back
everybody.
in September.
September, I think it's
On
the
Zoom.
2nd. Yeah, okay.
Yeah.
By Zoom.
Okay.
Well, thank you, everybody. Have a great rest of the week and see you in September.
See you all. Thank you.
Thank
All
you.
right. Thanks, everybody.